As it pleases the court, my lord, I confirm my appearances on behalf of accused number 1 and 2. As the court please explain.
As it pleases the court, my lord, I am still appearing on behalf of accused number 3.
May it please the court, my lord, I still confirm my appearance on behalf of accused number 4. Thank you.
As the court pleases, my lord, Mshalalo initial Z for accused number 5, my lord.
Yes.
As the court pleases, my lord, the state intends to call witness number 1 on the list of witnesses. The witness has requested the state to convey her objection to the live broadcast of her evidence, be it visual or audio. Up to this point, my lord, the proceedings have been carried live, both audio-visual, except in certain instances where the state would request that only the sound recording of the witness evidence be made. However, the witness has requested that, as I've just intimated, my lord, that the proceedings should not be broadcast live.
Yes.
And the basis of the objection are the following, my lord.
Yes.
Firstly, her personal safety. The witness is a well-known personality. She has to perform in public from time to time. And if these proceedings, my lord, are carried live, there's a possibility that the public might form perception regarding her evidence. And when she then performs publicly, her life might then be endangered. So the first reason, my lord, is for personal safety. The second ground, my lord, is that if the proceedings are carried live, that will put pressure on her. It will make her uncomfortable. She's under no circumstances, my lord, prepared to give evidence if the proceedings are carried live. There's, however, this important aspect, my lord, this important rider. The witness has got no objection if the journalists sit in court and report on her testimony. And just to elaborate on the fact that the live proceedings will bring a measure of discomfort on her part, this ground, my lord, is based on the fact that the live transmission of the proceedings will hinder her when she gives her testimony, in the sense that as has been the position with other witnesses, her evidence is compared to those of other witnesses, is subjected to intense scrutiny, it's criticized,
Yes.
and in certain instances, even in the social media, the evidence is subjected to scorn and ridicule. And the witness has indicated that this will naturally come to her attention.
Yes.
And it will unsettle and hinder her to continue with her testimony. My lord, we therefore submit that it is in the interest of justice that the witness be allowed to give testimony, and she's prepared, my lord, and she is here. She is prepared to give evidence, but subject to the rider that I've indicated that her evidence is not carried live. My lord, the inception of the proceedings, we have referred to the locus classicus of the NDPP versus Media 24 Limited and others, and HC Van Breda versus Media 24 Limited and others. It's a decision of the Supreme Court of Appeal.
Do you have those judgments?
Yes, it's 2014 Volume 1, South African Law Reports. And in that case, my lord, the SCA has laid down certain guidelines when the question arises.
And you say the citation of the case, the name of the case?
It's I'll give the
and you didn't give me the page.
citation. It's NDPP versus Media 24 Limited and others, and HC Van Breda versus Media 24 Limited and others.
Can you repeat the second one?
Is HC Van Breda. It's NDPP versus Media 24 Limited and others, and HC Van Breda versus Media 24 Limited and others.
Yes.
And the reference is 425/2017. And as I indicated, is the judgment of the Supreme Court of Appeal.
And with the NDPP one is 2014 in brackets 1 SA page?
Page 589.
Yes.
The judgment was delivered on the 21st of June 2017. 21st of June 2017.
Yes.
And the court referred to the well-known case of State versus Oscar Pistorius, 2014, Volume 1, SACR, page 589. The passage that we want to refer to at paragraph 59. The court held as follows, and we quote, "When there is a debate about whether a given court proceeding should be broadcast, a court is vested with the power to limit the nature and scope of the broadcast where necessary to ensure the fairness of the proceedings before it. The power of the court to do so is an inherent one, flowing from the provisions of Section 173 of the Constitution, and must be exercised in the interests of justice."
Yes.
And the court went further to point out that in making the decision, the judge may consider the following factors: whether there is a reasonable likelihood that such coverage would, firstly, interfere with the right of the parties to a fair trial; secondly, unduly detract from the solemnity, decorum, and dignity of the court; and at paragraph 72, which is the high watermark argument of the state, the court held the following, and we quote, "When a witness objects to coverage of his or her testimony, such witness should be required to assert such objection before the trial judge," which we are doing currently, "specifying the grounds therefore and the effects he or she asserts such coverage would have upon his or her testimony." This is, my lord, what we have just done. This approach entails a witness by witness determination and recognizes as well that a distinction may have to be drawn between expert, professional witnesses such as police officers and lay witnesses. And this witness will fall in the latter category. Such an individualized inquiry is more finely attuned to reconciling the competing rights at play than is a blanket ban on the presence of cameras from the whole proceedings when only one participant objects. And it says, under this approach, cameras are permitted to film or televise all non-objecting witnesses. And the court went further on at paragraph 73 to hold that if the judge determines that the witness has a valid objection to cameras, alternatives to regular photographic or television coverage could be explored that might assuage the witness fears.
Can you repeat that?
If the judge determines that the witness has a valid objection, so in other words, the court will have to determine whether the objection that we have brought to the attention of the court is valid, and if it's valid, the court can then make alternative arrangements that would address the fears of the witness. As indicated, my lord, the witness has got absolutely no objection if the journalists remain in court, in the public gallery, report on her evidence. The public would still be informed. The public will be informed of her evidence. This is as far as we can take this point, my lord. I don't know if there's any other aspect that the court would like to hear us on.
Just for you to put in summary what the witness request for, as I test with through you my understanding. My understanding is that this is a witness that is vital for purposes of these proceedings, and it is a witness that is coming unlike other witnesses who may come here by virtue of the nature of their job, like people who do forensics, people who deal with crime scenes and then formulate whatever is necessary, be it sketches or whatever. This is a witness who is to give an account of what took place on the day of the incident, and she comes as a lay person.
Indeed, my lord.
That's number one. Number two, you are saying that this witness is not objecting to the presence of journalists in the courtroom. In other words, she's still open to the feature of an open court.
Indeed, my lord.
Just as in the same way as any other court and as any other case, which is not this one, is proceeding all over the country today as we speak.
Precisely, my lord, without the glare of the cameras.
Yeah. And what she requests is that the cameras should not beam into her space as she testifies and transmit out into whatever coverage all that she will be doing and saying as she testifies.
Indeed, my lord, and she's indicated that she's got no objection if she walks in the corridor or in the street and you know, her photo is taken. She doesn't have a problem with that. It's only, my lord, as soon as she steps in the witness stand, she requests that she be afforded that privacy, my lord.
Yeah. And then the aspect of her face being broadcast as she testifies. That's the part that I find difficult to understand, in the sense that you are saying at the same time she's a public figure.
Indeed, my lord, she is a public figure, but she's coming to...
Meaning that her face is already out there.
Yes. No, it's not about the fact that her face may not be shown. As I've indicated, she doesn't have a problem if she walks in the corridor or in the street and a photo of her is taken, but she's requesting that as soon as she steps in the witness box and begins to testify, that there should be no cameras or no live recording of her evidence.
So she is saying whatever goes along with her testimony, her language, choice of words, demeanor, and everything should still be open or available for purposes of the open court, but be limited, not to go beyond the courtroom as she testifies, so that it will only be there for viewing by those who are available inside the courtroom.
No, she's indicated that she's got no objection if they generally sit in the...
That's what I'm saying.
Yes, in the gallery, and they just report in the normal way, like any other case, my lord, that she's got no problems with, my lord.
And then you raised issues of decorum and the stature of the proceedings, what we may loosely call the dignity of the court.
Indeed, my lord.
How can that be affected by showing the witness through a live feed?
My lord, as we've indicated that because of the nature of her status, there's likely to be intense interest in her as well as her evidence. In fact, there is already intense interest, my lord. And, my lord, that elevated interest will, as we've indicated, dissuade her from giving her evidence frankly and openly.
And then regarding what we will term the interest of justice,
yes,
you are saying that will be that may be affected by a preoccupation with the fact that she is being beamed broadly beyond the periphery of this courtroom as she testifies.
Indeed, my lord. In fact, the standpoint is if the decision, if she has to testify in an open court where there's live broadcasts of her evidence, she might have to reconsider whether she's still prepared to come and give evidence. And that, my lord, will affect the...
It sounds like it's twisting the arm.
Yes.
Isn't it?
Well, that is what came up in the discussion with her, my lord. That's her standpoint, my lord.
I think I've heard you. Oh, by the way, you referred me to as for NDPP case. I think I've read that one. The second case you quoted.
In that first case, the NDPP case, they referred to this second one.
Okay.
Of Oscar Pistorius.
Oh, okay. No. I'm not referring to the Oscar Pistorius one. I think the H.C. Van Breda. Oscar Pistorius I have read, but H.C. Van Breda
Okay. Versus Media 24.
Yes. What is the relevance of that case? The relevance of that case?
As I've just indicated, the case was quoted in the, in fact, the cases were consolidated.
Yes.
And the passages that I've referred to emanate from the ruling that was made during judgment of those matters.
Okay.
As a court basis.
As the court pleases, my lord. My lord, I'm sorry to disturb the proceedings, my lord. I'm not supposed to be standing. However, my lord, as I have been involved in this case from the beginning, my lord, I feel the application is directed to the media. And when we had encountered some problems between the media and the court proceedings, we had a legal representative of the media who came in last year, my lord. I am asking for a short adjournment, my lord, to verify from the media if the legal representative of the media is available to come, because the application is directly affecting the media and the media needs to be legally represented before we can proceed, my lord. I feel, and I'm asking with the leave of the court, just a 5 minutes adjournment, my lord, to verify if the legal representative of the media, which we have discussed with the interaction and the bail and the conditions for the work and for the working of media in this court, I feel he has to be informed that there is an application of this sort which has been brought by the state this morning. That's my request, my lord, before we all respond to the application by the state as the court is.
Advocate Baloy, I know you have a static plan around this case. What Advocate Mshololo is beginning to say is sort of pointing us to a bit of a process to come to a ruling. I stand faced with prospects of making a ruling without infusing the Audi alteram partem rule, in the sense that it's a ruling that will have everything to do with the media. And she's saying that the media is not properly represented, in that the members of the media that are here in their capacity as journalists or whatever capacity, whereas the issue of the role of the media in this trial, I think we have discussed it a bit in the past without covering instances where there will be individual objections. My sense is that I have to listen carefully to the objection. I have to carefully consider the concerns by the witness, much as I have to hear those whom a ruling might affect. So the reason why I'm addressing you is as to whether we must, of necessity, proceed with this particular witness, given the fact that we have now recognized that there's a process that has a bit of a process that has to unfold before I make a ruling about how we shall proceed from here. And that's why I'm asking you, if I may put it in simple terms, whether there's no other witness we can be dealing with who doesn't have objections, whilst we await this other process. I'm assuming that we might be told that the representative of the media is not here. At the same time, I may be preempting a situation where maybe we will be told that the representative of the media is here, rough and ready to deal with your request.
Yes. My Lord, that is the only witness that's scheduled for today and the next couple of days. My suggestion, and I agree with Advocate Mshololo, that maybe if we adjourn for a short while, so that the issues around the objection that has been raised are threshed out, and we can then take it from there.
Anybody else?
No objection, my lord.
No objection, my lord. Thank you.
appointment of their legal representative, my lord. Thank you, my lord. And one of the issue they've raised, my lord, is that they were not informed, they were not aware of this application, that they've been informed a day before. At least they would have sorted it out early in the morning before we started this court, my lord.
I should think this will tell everyone, including that media, that it doesn't seem to be your everyday case.
Yes.
If they will want to be considered all the time, I think they should make sure to be present.
As the court business, my lord.
We should not be delayed like we are being delayed now.
As the court business.
There is cause to wait for them now, but going forward, we will not have time to wait for people. This was unforeseen, I want to think, but I don't think it will continue to be unforeseen throughout the trial.
As the court business, my lord.
As a court, please, my lord, I can also just mention that the request came through yesterday evening, my lord. That's why the request came through yesterday evening, as there was no opportunity to inform everyone timelessly.
Yeah. All I'm saying is that this is happening in an open court, and it is open for people with interest to be in attendance, including everybody, including the media, and that attendance should be in a sufficient form. In other words, it should be such that can deal with all situations that arise. I think all of us should learn from this.
As a court, please.
Bommangalelo ngoba bengichaza nje ngenkathi ke sisathathe ikhefu ushuthi ke kulindelwe ke ukuthi intatheli kanye nalona ke ozokwazi ukukhulumela intatheli ukuthi ke akwazi uphendula kulesi sicelo esilethwe la enkantolo ukuthi ngempela ke icala lingazochubeka okanye icala lichubeka amakhamera ngekho manje ke laba ke beyintatheli sebeshilo ke okanye media ukuthi basazama ke ukuxhumana nommeli wabo ukuthi bezwe ke ukuthi uzophendula athini la enkantolo mayelana ke naleso sicelo. Silindeke ujaji okanye inkosi yenkantolo ukuthi akwazi ke ukusihola ukuya phambili ukuthi senze njani ke siyabalinda noma kanjani.
Yes.
As the court pleases, my Lord. My Lord, briefly 2 points. And I'll start by submitting that her objection and the reasons provided are flimsy, my Lord.
Come again.
Her objection and the reasons provided thereof are flimsy. Firstly, my Lord, by my understanding, she raises the personal safety objection, and secondly, she says there'll be pressure on her when she testifies if the matter is broadcast live, either visual or audio. Now, my Lord, the 2 previous witnesses, although I was not here during Tumelo Madala's testimony, my belief is that all of them testified without visuals. Only the audio was transmitted, and I don't think her safety will be prejudiced if her audio is transmitted, my Lord. And with respect to her personal safety, she says she's a well-known personality and people will have a particular perception of her evidence. The rigor of this trial, my Lord, is that everybody that testifies here is under scrutiny. The public will have their own opinion in the public court's opinion. It doesn't matter what happens out there. What matters is her story, her credibility in this court, not out there in the public, my Lord. Now, with respect to the second reason, the pressure on her, she then says if she's forced to testify when there's audio or audio visual, then she won't testify, my Lord. My Lord, we're not going to be held ransom by a witness, my Lord. She's a compellable.
Well, that's not even worthy of a debate. I mean, the question is whether she's a compellable witness or not.
Indeed, so, my Lord. I was coming to that. Indeed,
yeah. I mean, she will make a decision,
indeed, so,
and the law shall apply to her decision, and yeah, that's it.
And my Lord, those 2 reasons that she has raised that I've alluded to, there may be more. We must judge them by also what my learned colleague Advocate Baloyi spoke about, that is the quorum in court, federal rights, and the interest of justice. How her testifying, say for example, we agree on audio only, how is that going to prejudice the quorum in court? And what federal rights are going to be affected by the audio being broadcast out there, man? I'm asking
if you listened to Advocate Baloyi, because Zandile Kumalo has not yet testified.
Indeed, so, my Lord.
I seemed to read more consents out of her face being beamed.
Indeed.
Whilst she's testifying. The fact that she does not object to the media being present in court, and she puts no condition to the media being in court. I may not be exact, but it tells me that in terms of the audio side of it, she is not as emphatic as she is with the visual side of it.
My Lord, my reading is different unless Advocate Baloyi can clarify. I am of the belief that she says no audio and no visual. They can tweet, the journalist that is they can tweet whatever they tweet. I don't know how they do their work, my Lord. But she says adamantly that no audio or no visuals. That's my reading of what I heard from Advocate Baloyi, my Lord. Mr. Baloyi concurs, my Lord. That's the position, that no audio, no visuals.
Okay.
So coming to a solution, my Lord, for the sake of brevity and moving on with the day, my learned colleagues will address, but I think that we should proceed interimly because the media is waiting for their lawyer on an audio basis only. Otherwise, this day is going to be wasted if we wait for the media, my lord, as the court places.
Siyacela ke ummeli lapha ukuthi nanoma ke lo fakazi ozoza la enkantolo esekhulumile ukuthi ke yena unenkinga yokuthi amakhamera bekhona la enkantolo uke wakusho lokho ukuthi amakhamera kanti ke nokuthi leli cala lisakazwe ngaleyo ndlela ke futhi ke lisakazwe ngoma bona kude okanye lisakazwe njengomsakazo ojwayelekile ngazi ukuthi ke lo fakazi unenkinga ke lapho ukuthi leli cala liqhubeke ngazo zona le ndlela ezimbili zokuqhubeka ukusakaza leli cala kanti ke lokho ukusho kanjeni ukuthi kuyomfakela ingcindezi manje inkosi enkantolo iyasho yona ukuthi ungazi ukuthi mangilalele uadvocate Baloyi ungazi ukuthi inkinga isekutheni kungavezwa ubuso bakalona ke ozoletha ubufakazi bakhe kanti kuyoba iyona ke inselelo ekhona nje la enkantolo mayelana ke nalofakazi ukuthi ubuso bakhe bungavezwa hayi kangako ke ukuthi ubeke wathi ukusakaza ngokujwayelekile akanankinga kangako ummeli uthi yena uthi ukusakaza ngendlela ejwayelekile nokusakaza ngokuthi ke kuveza ubuso unenkinga lapho ilokho ke okukhulunywa ke abameli nje la kanti no advocate ulokho njalo Baloyi uyakuvuma lokho ke okukhulunywa ummeli
My lord, accused number 3 is informing me that he's got a family down there at KwaZulu-Natal who would have loved to be part of these proceedings. However, due to circumstances beyond their control, financially based, they are unable to be part of the proceedings live here. He's got a mother, he's got sisters and brothers who would have loved to be here. Therefore, an order that this broadcast, the audio broadcast of what is happening here at court, should be shut down would negatively have, would have a negative effect on those at home that are following these proceedings. He says it is in the interest of justice that those that are at home at KZN, KwaZulu-Natal, they should be afforded the opportunity to follow these proceedings. When he said that to me, my lord, it immediately comes to my mind as well that the deceased as well, he's got family members that are also coming from KwaZulu-Natal. He's been a star all over the show. The team that has been playing for the Orlando Pirates, followers of that team, my lord, they would want to know what is happening in this trial every step of the way. An order, therefore, my lord, that says there should not be an audio-visual, not visual. An order, therefore, that says there should not be an audio broadcast of these proceedings will infringe upon their rights on the freedom of speech. My lord, the authorities that my colleague has referred to this court to are simply saying that there should be a balance between what is in the interest of justice and what is not in the interest of justice. But imperatively, he read to this court a portion that says the court should always be loath in deciding on what it is in the interest of justice on the basis of only what one person says. I will not go into details about what my colleague has said about the reasons that she gave. Indeed, they are very flimsy. They are neither here nor there, my lord. But another aspect that also came into my mind, I think in the testimony of Mr. Madlala, there was a Netflix thing. I don't know what is that. But what it is in my mind is that there was a film. Apparently, he was invited to come and participate in the film and everything. What immediately comes into my mind, my lord? I'm actually asking myself, because I'm not privy to what was said in the trial, though I've got records. Well, I requested records and I did not get them. I'm just asking myself if the very same witness was not part of that film as well. If she was, then her reasons for not testifying through the audio here are dead and buried. But
I don't know whether you can take it that way, because you can at the same time say lessons out of that brought her to where she is now.
Excuse me, madam.
I'm saying the fact that she has participated before,
yes,
if she did, cannot automatically mean that she should be compelled to participate in that fashion now, because it could also be said that lessons out of previous participation have led her to the position she is at now.
That will be the court's interpretation, but I've got a different interpretation, and mine is.
Yes, I'm saying the fact that she has participated before cannot lead to one conclusion.
Yes, my lord.
Only that then she is able and ready and must be compelled to participate now because she has done so in the past.
No, I'm not saying, my lord, that she should be compelled to participate. The court has already alluded to that point, that we don't even need to mention it because it's just a compellable witness. But what I'm saying is, for the fact that if she was part of that Netflix film, then I'm saying her excuses now that whatever that she would come and testify about her court here should not be made known to the public members. If she advances that reason on the basis of her being part of that Netflix film, then those reasons, my lord, are dead and buried. They are neither
it's also a dicey point, because you are not saying to me she has participated. You are not saying she has not.
I'm informed by my colleagues, my lord, that she basically has participated, which is why I am saying if she was a participant in that Netflix thing, then for her to come and say that the people out there should not hear what she would be testifying about here at court is doomed. Exactly. But further on, my lord, we're hearing from the submission from the state that on her own she says she's a public figure. She's out there, everybody knows her. So I'm very surprised, my lord, to hear that her testimony here at court will make her feel uncomfortable. She will be criticized. It will be interpreted in different ways. My colleague has already alluded to that, my lord. So it's my submission, my lord, that in as much as there are also two witnesses who were in that very same house where she was, and that's evidence before court, that makes no difference. She cannot be elevated to some position that is more that's not similar to the other witnesses who were actually at court, my lord. Because all their evidence, if I follow the state, will just flow in the very same pattern. Therefore, her reasons to request that she should be treated specially, I've got no basis, my lord. And also the authorities that the state has referred to, they also give this court a discretion. They don't say that the court, once an application of this nature has been brought, then the court must do this. No, the court says, the authorities that my colleague have referred to saying to this court, the court still has a discretion. It must exercise this discretion on the particular, on a case-to-case basis. It's not an umbrella decision. I would therefore also concur with my colleague who says that let this court proceed with the very same fashion that it has been happening, audio and not visual. Thank you, my lord.
Come again. Audio what?
Audio and not visual. The same way in which these other witnesses have been doing here at court, my lord. Thank you.
Can I just find out, is it true that none of the witnesses testified with visual beaming at the same time?
No, that is the case, my lord. It's only their voice, but their visuals are not beamed. It's only their voice. That is now in respect of Tumelo and Mr. Madlala, Mr. Twala. Thank you, ma'am. State can confirm.
Indeed, my lord.
Ngisho yomeli ke naye kulesi sicelo ukugcizelela ukuthi ushuthi lo fakazi lona ke akwazi ukuthi azochubekela enkantolo ethula ubufakazi bakhe lana ukuthi wonke ufakazi obizwe inkantolo ukwazile ukuchubeka ukuthi ke ethula ubufakazi bakhe la enkantolo ngaphandle kokuthi amakhamera angabi khona. Kanti ke kugcizelelwa ukuthi laba abanye ufakazi nababefikile lana futhi ke ubuso babungavezwa kumabona kude kahle kahle ke iphimbo nje lodwa okanye ke yizwi lo fakazi lalizwakala. Manje ke isicelo ukuthi ke asichubekeni ngaleyo ndlela kungabe ukuthi manje sekubonakala kwangathi lo fakazi yena ke ufuna ukukhushulwa phezulu kwabanye ofakazi abalethwe la enkantolo. Ngazi ukuthi yena ke ungumuntu oyikhethile ilokho okukhulunywa ummeli asichubeni ngendlela ebesiloko sichubeka ngakhona ngalo fakazi lona ke ilokho akukhulumayo. Kanti ke okunye akuphawulile ukuthi kuye kwazwakala ukuthi uba Madlala ubenza ifilimu la ye Netflix. Kwazwakala nokuthi ke lo fakazi lo bekuyingxenye yaleyo film ye Netflix. Mangabe ke ukwazile ukuthi abambe ichaza lapho kuleyo film uzohlulwa yini ke ukuthi manje makeze la enkantolo kunamakhamera azothula ubufakazi bakhe la kusenkantolo yathi ke hayi ukuthi seke wabamba ichaza la kwenza khona ke amafilimi akusho ke manje ukuthi usephocelekile ukuthi nalana ke ezokwenza ke athule ubufakazi bakhe kubhekwe leyo nto yokuthi ukwazile ukubamba ichaza phela lapha yana. Ubaba umnisi uyachubeka ke uyasho ukuthi phela lo muntu lona nkosenkantolo useyaziwa vele uyaziwa umphakathi manje ke angeke aze athuswe indaba ukuthi manje sekulethwa ke amakhamera lana ke useyithole ngaphansi kwencindezi. Inkantolo ke mayisebenziseke umqondo wayo mayilana ke nalesi sicelo. Thank you, my lord.
Yes.
Yes, thank you, my lord. My lord, yes.
That should remind everyone else.
Yes, Yes, thank you, my lord. My lord, this application brings into sharp focus the interference between the functioning of the criminal justice system on the other hand and the interests of one individual and the participation of the media houses on the other. My lord, it then brings me to the provisions of the Constitution, that is our Constitution of the Republic of South Africa, Act number 108 of 1996. In particular, Section 16, subsection 1, Section 16, subsection 1A, small letter A in bracket. It guarantees everyone the freedom of expression, which includes the freedom of the press and the media, as well as the freedom to receive and or disseminate information and ideas. My lord, in the case of the multi-choice versus NPA, 2014 volume 1, SACR 589, which is a decision.
Page?
2014 volume 1, SACR 589, which is a decision of this division, the North Gauteng.
I'm not hearing the page each time.
589, which is a decision of this division, the North Gauteng. It's a decision by the judge president of this division, Mlambo JP. In that case, my lord, the two cases which are of importance are cited at 594, which is the case of the South African National Defence Union versus Minister of Defence and another. It's 1999 volume 4 SA 469 CC. It's a constitutional court decision. 1999 volume 4 SA 469 CC in bracket.
Page?
469. My lord, at page 594 of the multi-choice versus NPA decision, the following was said, and I quote, "Our Constitutional Court articulated the content of this right in South African National Defence Union versus the Minister of Defence and another in the following terms," and I quote, "Freedom of expression lies in the heart of a democracy. It is valuable for many reasons, including its instrumental function and a guarantor of democracy, its implicit recognition and protection of the moral agency of individuals in our society, and its facilitation of the search of the truth by individuals and the society general. The Constitution recognizes that individuals in our society need to be able to hear, form and express opinions and views freely on a wide range of matters," close quotation. On the very same page, at paragraph 7, the following was said, and I quote, "In a further articulation of the freedom of expression right, the Constitutional Court in Kumalo and another versus Wolomisa, the case is reported at 2002 volume 5 SA 401 CC, stress the following with regards to the role played by the media, and I quote, "The print, broadcast, and electronic media have a particular role in the protection of freedom of expression in our society. Every citizen has the right to freedom of the press and the media, and the right to receive information and ideas. The media are key agents in ensuring that these aspects of the right to freedom of information are respected. Close quotation. My Lord, I'll also concur with my colleague, Advocate Mnisi, that the evidence of Madlala and Ntwana has been broadcast by voice feeds. It cannot be held, my Lord, at ransom by the application of one individual. The interests of the society as well as the interests of the media must be weighed vis-a-vis the interests of this one individual. It is my submission, my Lord, that the application is baseless, it has no basis, and it tends to be dismissed. Thank you.
Beshilo-ke nobaba uNcumalo andikuba umamsholo lezokhuluma nje ingenelele ukuthi usebenziseke imibandela evela laphana-ke ku-section 16 yomgaqo-seko wethu, section 16 subsection 1 i-subparagraph A, small letter A, lapho-ke ekhulume ngokuthi-ke lana-ke i-constitution yethu iyayigcizelela lento ukuthi umuntu ukhululekile ukuthi angaze akhululeke, ngamanye amazwi akwazi ukuveza imizwa yakhe mayelana-ke nodaba oluthize, lento esiyibiza ukuthi i-freedom of expression. Kanti-ke ney'ntatheli zinalo lelo lungelo nazo ukuthi zikwazi ukuthi zicokeleleke ulwazi oluthize oluzokwenza ke ukuthi wonke umuntu olalele akwazi ukuthi ngizwile ukuthi kwenzakalani ngaleli cala, nami ke ngizoyithathela ezami iy'nqumo mayelana ke nokuhlolisisa ke leli cala. Kanti ke usebenziseke imizekelo ekhona emthethweni okanye ey'ncwadini zomthetho ku multi choice versus NPA, lapho ke judge president umlambo ukwazile ke alethe ke ezinye zey'nqumo la enkantolo, kanti ke kwakuyisinqumo sase constitutional court ke leso ke lapho ke kwakuyicala le South African National Defence Union versus Minister ye Defence. Kukhulunywa ngalo lelo lungelo lokuthi umuntu unelungelo lokuthi aveze imizwa yakhe ngodaba okanye iphuzo elithize. Kanti ke lokho ke kusenkabeni okanye ikhona ke idemocracy yethu ezama ukugcizelela ke lokho. Wonke umuntu uyakwazi ukuthi asebenzise lelo lungelo ukufinyelela ke iy'nqumo zabo mayelana ke nodaba oluthize. Konke lokho ke nakho ke kuyaphelekezelwa lana icala likaKhumalo nomunye okanye nabanye ebhekene noHolomisa. Lento ye freedom of expression iyona ke ebaluleke kakhulu. Amalunga okanye ithimba le media okanye intatheli zethu eyikwazi ukuthi thwebuleke ithombe okanye bathathe udaba bakwazi ke ukuthi emva kwalokho ke balethe udaba kumphakathi, banawo lawo malungelo nabo, amalungelo wabo lawo, futhi ke lawo malungelo afanele ukuthi ahlonishwe. uthi ke bakunqumana makeqhubeka uyavumelana no advocate Mnisi ukuthi ubufakazi bakaMadlala ngomzekelo ubufakazi bukaThwala kwasetshenziswa ke ama voice feeds shuthi ke kwakuthathwa ke ama voice wofakazi ababekhona la enkantolo manje ke angeke nje ufakazi oyedwa nje amisa inkantolo abambe izandla zenkantolo ukuthi inkantolo ingaqhubeki ngoba phela ke eneyifiso zakhe ke. Thank you, my lord.
Yes. Thank you, my lord. My lord, this is an embarrassment to the South African law proceedings that at this stage during trial we are still dealing with this kind of an application. An issue, my lord, which ought to have been discussed at a pre-trial conference stage before we started with this trial. My lord, procedurally, it is the duty of the state to consult with all the witnesses, state witnesses, before the trial starts, in order to ascertain issues like of this nature that we are facing today.
Yes.
My lord, we ought to have been informed by the state at the beginning of this trial, after realizing that the media has been allowed to broadcast these proceedings, that yes, the state does not object the broadcasting of media, but on conditions of the following witnesses who might be affected by this.
Can you really say that? Because Advocate Baloyi said it clearly, that last night he received an email or whatever he received.
My lord, I'm still coming there. I'm just stating the procedure, what ought to have been done by the state at the beginning. That ought to have been canvassed with all the witnesses, my lord, who will be adversely affected by the broadcasting, so that this court will know that there are exceptions to other state witnesses like this one, and maybe other witnesses, if there are any, we don't know. We have not been informed. We ought to have been informed that this broadcasting is accepted but subject or with the exceptions to the following witnesses. Coming to this case, my lord, yes, I agree, my lord, that the state has indicated that they were only informed last night. Why only yesterday? Why only on the last hour? Because during trial preparation, the state ought to have been informed of this objection.
Yes?
Secondly, my lord, after the state had known or had been informed of this application, we were never informed as the affected parties. Via the email, my lord, the state had the whole night to prepare this application. And we are now being ambushed by the state to read and prepare our responses, wherein we're negatively affected by the application. That is unfair, my lord. Secondly, my lord, coming to the reasons stated by this special witness, who says because of a personal safety.
Is that a designation, special witness?
Oh, my lord.
I don't want us to use this process to ridicule anyone.
My lord, can I just withdraw that? Can I just withdraw that?
Yes.
Thank you, my lord. He says he's bringing this application for her personal safety.
Yes.
Our lives, my lord, I mean the court officials by our court officials, accused persons, all our safety has been compromised by the broadcasting, my lord. But we have allowed it to proceed because we were respecting the court order, my lord. And we also understood that the freedom of expression also allows the media to broadcast the proceedings.
Yes.
And the second point, my lord, that has been raised by the state is the concern about the public comments and public opinions, whatever that is, will be raised or can be raised after her testimony, comparing her testimony with other witnesses and so forth, as it has been stated by the state, my lord.
Yes.
That has got no adverse effect to this court. This court is not bound, my lord, by the public opinions, by public comments, by public critics, my lord, of any sort. This court, when deciding or when deciding on this matter, will be bound by the evidence presented before this honorable court. In other words, my lord, it will have no adverse inference to this court if her evidence is broadcasted as we have been doing. Secondly, my lord, the issue of safety, I myself, as the defense counsel for accused number 5, had been posted on Instagram and all social medias by the same witness, my lord. And I will ask this court to adjourn right now so that I print all the statements that this witness has made about myself, my lord.
Is that on point? Is that on point here?
It's part of my address, my lord, because the issue of personal safety has been raised, my lord, by the state. So I'm saying, my lord, if we were to consider the personal safety of this witness in isolation, what about the personal safety of other people, including myself? And I cannot make those submissions without presenting those pictures before this court as a self-evidence, my lord, that my safety also as well has been compromised, but I'm proceeding with the trial. And I will be making submissions to say, to ask this court not to consider that fact in isolation, but it must consider it in respect of all other people. The pressure as well, my lord, that has been stated as another reason that broadcasting will put pressure on her. What kind of pressure, my lord? It has not been placed before this court. How? The nature of extent of the pressure, the prejudice. In what way, in what sense will pressure? Because, my lord, this is a person of a public figure. This is a person who is known by everyone. This is a person, my lord, who has been posting herself on her pages of social media about this case. And then if today he's saying that he will encounter pressure or suffer pressure, in what way? That had to be placed before this court. This is not a person who is foreign to media language. He's a fan. Instead, my lord, of media usage. And then further to that, my lord, the issue of Netflix documentary, I know the court is not aware of that document, my lord. But my lord, this is a document wherein this particular witness had participated to it, my lord.
Did you hear what I said about Netflix when your colleague?
Yes, yes, my lord.
Yeah,
Yes,
I'm saying that does not lead only to one conclusion.
yes.
The one conclusion, which is what you and advocate, the representative of accused number 3 said, is that she can do it, she has done it, and nothing happened to her. I think that is what you are saying, after she did it. But I'm saying, yes, that is the one side of it. The other side of it is, could be that out of participating in that next Netflix or whatever, there could have been other developments.
As the court, exactly, my lord, that's where I am.
Yes.
There is no evidence there which has been placed before this court to
Yes.
say as a result of her participating on the Netflix, this is what she has suffered.
Yes.
We have no evidence. Instead, what we know is that she has been paid for participating. She benefited without any prejudice. And now today, she says she will suffer prejudice. And that document, my lord, the Netflix documentary, is published, is circulated to everyone. She has testified, she has said a lot about this case, my lord. And she never asked any limitations of maybe her face or visual not being recorded in that documentary that is being circulated, my lord. Now, when we are dealing with a case, my lord, wherein this court is supposed to listen to the evidence of each and every witness in order to decide on this matter. Netflix, my lord, benefited and had no duty to make any decision. But this court, which is seized with such a crucial duties of determining as to who actually killed the deceased, then we are confronted with this application. My lord, it is my submission that this court should not entertain that application. This court should not grant the application. We understand for the issue of safety, like the first and the second previous witnesses. Their faces have not been shown. Let's proceed.
I think you should. I think you're not putting it correctly. I don't think I can take it from where you're saying I should make no considerations of safety, because that would, if I were to do it, it would even be discriminatory. Because when an incident took place, which seemed to border towards placing the safety of Tumelo Matala into jeopardy,
Yes.
this court intervened. I even cleared this courtroom
Yes.
of some of the individuals who seemed to be implicated.
Yes.
That was subsequently dealt with the journalist, and we arrived at a very firm understanding that whatever we do, we should not deliberately, or if we can help it, place anyone safety in jeopardy.
Yes, my lord.
So I cannot today say no, I no longer care about the safety of anyone.
My lord, I'm not necessarily saying this court should not take care for the safety of the witnesses. But I'm making submissions to say, my lord, this court has entertained the safety of the witnesses to such an extent that Mr. Madlala and Mr. Twala, their faces, it was an order of this court that their faces should not be visualized in the interest of their own safety, which is the precedent that has been created before this court, of which I ask with due respect that that should also continue with the next witness. The only issue, my lord, that I'm raising, that I'm asking this court to consider regarding this witness now, who is asking more than what has been ordered by this court, is that if she is genuine about her safety, she ought to have considered that first when she went on Netflix. If, my lord, this witness was genuine and sincere about her own safety, she should not have posted herself on media platforms, my lord. As I've said, my lord, I'm asking for a short adjournment so that I'll print those images to show the court, to support my point, my lord, that I'm submitting before this court. I'm not saying this court should not consider, but I'm just putting it as a point of consideration before this court.
Yeah, well, it brings me to a point I was to raise later, that it's coming to where everyone will have to come up with concise heads about it, whilst we wait for the media, because I don't know when the media will be coming. There is encouragement. I think it started with Mr. Ramsipidi for the court to rule that there be audio beaming, and that we proceed. But then Advocate Baloyi assures us that it is part of what is objected to.
Yes.
If it is objected to, I have to listen to both sides and then come up with a ruling.
With the ruling.
Yeah, I think there will be a bit of a cart before the horse if we now start to make a ruling about these proceedings when there is an objection about how they are unfolding.
Yes, my lord. My lord, maybe before we adjourn, can I just include one point? So my lord will note that I haven't finished with my submissions.
Yeah, I was
when
also
it
to
comes
say that
yes.
although I don't know whether the postings done by this witness will take the point any further. If you were to strongly want to do that, I think it will be part of your written arguments.
Part of, my lord?
It will be part of your written arguments.
Arguments,
Yeah.
as the court basis, my lord. So it means that, my lord, it means I will have to pause here, or should I proceed? And
I think you should argue everything except that I'm saying that it has come to where I think everyone should come up with concise heads whilst we wait for the media representative. Yeah.
And
if
obviously, my lord, we won't be ready with the concise heads of arguments today. Definitely, my lord. I don't know, my lord. I personally won't be ready with the heads of arguments after lunch today.
Yeah. Because some of you have been quoting passages here, and
Yes,
I
my
think it will be best if I have it in written form before me.
As the court basis.
Please, the court, ma'am. I think there's a challenge with the heads of argument, madam, because the procedure in respect of filing of heads of argument is the applicant must file their heads of argument on a certain date. Then we should go through them and respond to those heads of argument on a certain date. I can assure this court that it might take the whole week before that process is finalized, my lord. I would therefore submit, my lord, that I'd actually request the court, my lord, that the matter may be decided on the basis of what has been submitted from the bar, my lord, in the interest of time. Because as I'm saying, filing heads of argument...
Without listening to the media?
The media included, my lord. The media included, of course. But what I'm saying is, if the court were to request us to file heads of argument, we're going to request the state to file their heads of argument first.
Advocate
be given
Baloy?
an opportunity to respond.
Advocate Baloy,
And that
what
might
is
take
your
the
take
whole
on
day,
that?
my lord.
As a court, please, we might perhaps need to short-circuit the process. The state is prepared to reduce what we've presented orally to writing within a short space of today still. I've been informed that the legal representative for the media is on the way.
Yeah.
And yeah, we'll also be guided by what they say. But I think it's a matter that maybe we can
Yeah, and
Did-
Mr. Okay,
argue. Yes, I guess suggested by Advocate Nissen.
yeah. And I don't know, you seem to be saying that we should avoid written heads because there's a process to be followed. This case, the case that we are busy with is a real case. It's precedents forming. And I don't think we should avoid things merely because they will entail laborious processes. If we have to deal with this matter and do justice to it, we should do it. We should do everything that is necessary for us to arrive at that objective. So he's saying he will short-circuit it and reduce his presentation into writing and relay it your way. And I think that's the only way we should do it. We should not be seen to have ignored certain processes just because we want the shortest route towards what we want.
Madam, I'm not saying that we should not file heads of argument, but I'm only alerting to the court with regard to the process of filing heads. The state will be, I don't know when will they be filing their heads, but then there needs to be dates. Probably the state will come and file their heads on Wednesday, I don't know when. Then we'll have to have an opportunity to respond to the heads of argument and probably file ours on Friday. Because we definitely...
Why must it happen that way?
Because
he's saying he can short circuit, and he even use the word today. Is that not what you said, Mr.?
Indeed, my lord.
And then it means, my lord, if the state says they are going to file their heads of argument today, then it means we also need to be given the opportunity to go research, because we just don't file heads of argument without research. Otherwise, we'll be flouting the process. We need to go and do research in response to what the state would have raised in their heads of argument. So I'm not so sure whether we'll be overnight, we'll be in the process to file those heads of argument, my lord. But in any event, we need to respond, and we'll have to have sufficient time to respond to their heads of argument. To me, that says the state must file their heads first. We go through them, we formulate our views around their heads, we go to research, respond to their heads of argument, then thereafter file our heads. We draft them and file them. The whole week is gone. But I'm not saying, my lord, that the state, that if the court deems it necessary that we file heads of argument, that should not be the case, my lord. I'm only saying it that should also be one of the considerations when the court says we need to go file heads of argument. But my submission would have been, to me, it would have, I would propose that the court, on the basis of the submission, this oral submission from the bar, that the court makes a decision on the basis of that. I hear that the legal representative from the media is coming. Once it's addressed, probably then the court can take a short adjournment and probably go and analyze all the argument and then bring back a decision.
I have already said that.
As it please the court.
My lord, can I just make a submission, my lord, with due respect? May I suggest, my lord, that because the state is ready, can the state file their heads by 4 o'clock today,
Yeah.
and then the defense council, including the media, be ordered to file their heads at least the earliest by tomorrow at 4 o'clock, so that on Wednesday we are back for the ruling.
Okay.
That's a suggestion, my lord.
My lord, also, just to truncate, like Advocate Baloyi says, the time period, I think as the defense here, that's my suggestion, we can file only one set of heads of argument and one of us will then represent us for that. I'm not sure whether that will be the correct procedure, my lord, because my learned colleagues, Ms. Mushololo and Advocate Ngumalo, have cited authority. So it's just to summarize that authority together with our addresses from the bar, then it truncates the time as well, my lord, as the court pleases.
That can be arranged, my lord, amongst ourselves, my lord. There is no problem with that.
What remains for now is to wait for the
For the media.
media.
Yes, my lord. I suggest that we adjourn until 2 o'clock. They'll be here by 2 o'clock for the final instruction, my lord.
here at both television and radio, and I present argument on behalf of all of them.
Yes.
At the outset, it's unfortunate that this application wasn't brought on notice to all interested parties in the form of a formal application to give, of which my clients are one, which would have given us a better opportunity to have this matter fully ventilated today.
Yes.
I understand there has been some suggestion that the best way forward would be for heads of argument to be filed with the suggestion that the applicant file heads of argument by 4 o'clock tomorrow. The representatives of the accused and the media file heads of argument at 4 o'clock on Wednesday, or on Wednesday, and the matter be on
I think you got it wrong, because the state had suggested that they might do it today still, so that the others will file by 4 o'clock tomorrow.
No, that's fine. We can file on 4 o'clock tomorrow and avail ourselves on Wednesday, or whenever you decide is the opportune time to address you regarding access funding.
Chike, ukukhulumela ke i-electronic media, sikhuluma ke ngomabonakude okanye nje umsakazo wendlela. Ukuthi ke uma ngabe ke lolu daba okuyinselelo namhlanje okanye inkinga esinayo namhlanje ike yavelela phambilini, bese kwazi ke ukuthi mhlambe singaveza uvo lwethu ngendlela esemthethweni efanelekile. Kanti ke nawo ama heads of argument okanye ke amaphuzo wokubangisana ngizwile ke ukuthi abefanele ukuthi afakwe ngo4 o'clock namhlanje. Kanti ke uthi ke yena akanankinga yokuthi ama heads of argument afakwe kusasa ngo4 o'clock. Futhi ke kuzoncika ekutheni ke inkantolo ithini ke yona mayelana nalokho, mhlambe ke bese uyaqhubeka neqala mhlambe ngolwesithathu into enjalo, usezandleni zenkantolo ngamanye amazwi.
My Lord, as advised, we've had limited time to prepare argument, but more important, very little time to hear argument on behalf of the state as well as the accused in relation to the matter. I've listened to perhaps 15 minutes of the state's argument and none of the argument from the accused, although they gave me a very limited version of what they had said, and my argument today is based on the limited time I have.
Manje ke shothi ke isikhathi sincane silinganisiwe nje isikhathi ukuthi silungiselele ukuthi kulethwe lokhu kubangisana. Isikhathi sincane ngakule hlangothi lombuso kakhulukazi futhi nakuba mangalelwa ngapha. Ngaleyo ndlela ke kuyinselelo into leyo ukuthi ama heads of argument afakwe na leso sikhathi sincanyana lesesikhona.
My Lord, my argument will proceed on the following basis. First, I will lay out certain principles and established case law, both in relation to open justice as well as in relation to access by the electronic media to court proceedings.
Manje ukukhona nje amaphuzo athize okanye inqubo ethize ebingathanda ukuthi mhlawumbe ngiyisebenzise mayelana ke nendlela okusetshenzwa ngakhona ubulungisa obusebenza ngakhona kanti ke nendlela imedia nayo isebenza ngakhona.
Thereafter I will proceed to answer certain of the arguments made in the limited footage that I've seen by the state regarding why they seek the order which they now seek, which prohibits provides a total ban on the evidence of the next witness to give evidence.
Emva kwalokho ke ngizoba sesimeni sokuthi ngikwazi ukuphendula izathu ezenza ukuthi ke umbuso ubone kuyindlela okuyiyona ke lena yokuthi ufakazi alethe ubufakazi bakhe ngendlela isicelo silethwe ngakhona.
Sorry, my learned friends correct me. When I say a total ban, I mean a total ban on the electronic media in any way broadcasting the proceedings. I understand that representatives of the media will be able to be in court and will be able to report on the proceedings, which in itself, as you will see, is an important principle that I will turn to do.
Kanti ke bengaqondile ke mina kusho ukuthi kuyo yonke iminyango yemedia iyona ke iminyango engizokwazi ukuthi mhlambe ngikhulumele bakhona bakwazi ukuthi bazokhulumela ke imikhakha ethize khona lana kwi-media bengaqondile ukuthi ngikhulumele wonke umuntu ngaleyo ndlela.
My Lord, I ask you to bear in mind as an overriding issue to be remembered when hearing my argument, and even when hearing my argument, the argument from the state and the accused, and in considering the relevant case, is that the objecting witness has not given any evidence in court today concerning why she, for example, fears for her safety.
Manje ke lona obefana mhlawumbe athole ubufakazi bakhe namhlanje la enkantolo ubengakaze athole ubufakazi nokuthi kacacisela inkantolo ukuthi ingani enovalo kanye saba ukuthi imedia ibe khona ke uma ethole ubufakazi bakhe la enkantolo.
This evidence is merely presented by the state from the bar, and I will show you that this is contrary to the established principles as to how witness testimony should be dealt with.
Manje ubufakazi nje obuqhamukeke laphayana la umshushisi ekhona kanti ke ngizokwazi ke mina ukuthi ngibonise inkantolo ke ukuthi lokho kumelane kanye nelokho njani ke indlela ubufakazi lethwa ngakhona la enkantolo.
My Lord, the constitutional principle of open justice is a well-established principle in South African law.
Inqubo lena ebizwa i-open justice okanye ke ubulungisa obuvulekile okanye obuvulelekile ubulungisa okuyibona ke ose buqinisekisiwe lana ke enkantolo okanye khona lana eMzansi.
I do not intend presenting argument in detail insofar as open justice is concerned, but I would like to refer to certain cases and quotations from cases which establish the principle.
Angeke ngikwazi ukuthi ngiqhubeke ngokubangisa ngokujula mayelana ke naleyo nqubo ye-open justice ngaphandle kokuthi khona ke okuthize engizokubalula ke uma ngiloko ngikhulumisana lenkantolo ngaleyo ke open justice.
The first case I'd like to refer to is a constitutional case. It's the SABC, South African Broadcasting Corporation Limited, versus the National Director of Public Prosecution and others.
Manje ke elokuqala okanye umzekelo weqala engithanda ukuthi mhlambe ngibalule kuwo ilona ke we SABC Limited versus lokunjani ke in National Public Prosecution or in National Public Prosecution.
If I can give you the citation, my Lord, it's 2006 ZACC 15 semicolon 2007 1 SA 523 CC Constitutional Court. The relevant paragraphs are paragraphs 28 and 29.
Kanti ke ama paragraphs azosetshenziswa ke kulelo cala njengoba ke selibekiwe eselicacisile kanjalo ke paragraph 29, 28 no paragraph 29.
I won't read you all those paragraphs, but importantly, the court, per Langa CJ, held as follows. The vibrant and independent media encourages citizens to be actively involved in public affairs, to identify themselves with public institutions and derive the benefits that flow from living in a constitutional democracy. Access to information and the facilitation of learning and understanding are essential for meaningful involvement of ordinary citizens in public life. This corresponds to the vision in the preamble to the Constitution of laying the foundations for a democratic and open society in which government is based on the will of the people. It also reflects the foundation principles of democratic government which ensures accountability, responsiveness and openness.
Rafupeke usho khona lokho ke ulanga CJ ukwazile ke ukuthi akhulume lokho ukuthi izakhamuzi ke zinelungelo ukuthi kube nechaza elithize abalibambayo kanye kube nokuthize ke abakutholayo malana ke namacala futhi ke ulwazi oluthize oluqhamuka enkantolo banelungelo ke okanye izakhamuzi zinelungelo lokuthi lithole lolo lwazi. Kanti lokho ke kuyisithombe kumfanekiso omuhle omayelana ke nomgaqoseko wethu kanti ke nesisindo somgaqoseko wethu esibonisa ke ukuthi uhulumeni wethu unguhulumeni wentando yeningi ngamanye amazwi.
My learned friends to my left suggest, and will be subject to your guidance, that perhaps it may be in the interest of finishing the proceedings sooner rather than later, that quotes from cases not be interpreted, but I'll be subject to your guidance in that.
Will you be including them in your heads?
I will be including them. Then, my lord, the second case is the famous Oscar Pistorius case, which was held before Malumbo JP, who gave the judgment.
Yamacala umzekelo ilena ka Oscar Pistorius esonga kuyo ke ukukhulumisana nenkantolo.
My lord, again, I'm not sure if you want me to give you the citations now because they will appear in my heads.
Yeah, do that.
Sorry?
Yeah.
You want me to give it to you?
Yeah.
It's Multi-Choice Pty Limited and others.
Here.
Versus National Prosecuting Authority and another.
Here.
In re S.V. Pistorius. (2014) Volume 1, SACR 589 GP, and I quote from paragraph.
What page?
589.
Yes.
And I quote from paragraph 23, which deals with the rationale for the principle of open justice.
Yes.
According to Malumbo JP, and I quote, "Our Constitution is underpinned by a number of values, and for purposes of this case, I refer to openness and accountability. In this regard, it is also important to take cognizance of the fact that sections 34 and 35, subsection 3C, make it very clear that even criminal proceedings in this country are to be public. The basis for this is that courts of law exercise public power over citizens, and for this it is important that proceedings be open, as this encourages public understanding as well as accountability." And the conclusion to be drawn from that and the various other cases is that what open justice means, it's that it's more than keeping the doors of the court unlocked so that 100, 120 so people, or in a smaller court, fewer people can watch the proceedings. It means that court proceedings must be meaningfully accessible, visible and audible to any member of the public nationwide who want to hear accurately what the proceedings are about.
Manje ke umzekelo weqala leli lika Oscar Pretorius kanti ke ile yakhe ise multi choice limited and others versus the National Public Prosecution nabanye ke khona lapho as with Pretorius uJaji Mlambo ke kakhulukazi sesi badla khona lapha ke ku paragraph 23 ya leso sinqumo ke lana kukhulunywa ke ngenqubo yokulinganiswa ngendlela eyithile zokusebenza la enkantolo kakhulukazi ke kukhulunywa ngayo lento lena ye open justice usho khona lapho ke ukuthi umthetho kwamele ukuthi kube indlela osebenza ngakhona la enkantolo uvuleleke kumphakathi ukuthi ke ukwazi ukubonakala ke ukuthi izathu zikhona ezithize ezimayelana ke ngeinqumo ezithathwa inkantolo futhi abantu bakwazi lokho ukuthi inkantolo ithatha inqumo enjena ngaphansi kweziphi izathu kanti kusetshenziswe yona ke isection 34 nesection 35 emayelana ke nenqubo kanye ukuhanjiswa ke kwamacala la enkantolo futhi ke isection 34 ne35 lena yona ke ye-constitution yethu kanti ke izwe lonkana kwameleke ukuthi litholeke iminyango yezinkantolo ivulekile ukuthi ke ma icala lichubeka imedia ikhuleke ukuthi ikwazi ukuthatha okuyikhona okumqokwa okuzophana ngolwazi kuyilokhu njani lethu kwizwe lethu kanye ihlalamuzi okanye izakhamuzi zethu.
My Lord, I think there can be no doubt whatsoever that these proceedings are clearly in the public interest, and I don't intend.
Sometimes you are lowering your voice. I can't hear.
Sorry, my Lord, I'm saying I think there can be no doubt that the proceedings in this matter are clearly of public interest. I don't intend addressing you in this regard, but will do so in the heads of argument, other than to say that they concerned a well-publicized murder of a public figure, and in fact a national soccer hero.
Lana ke indlela ke inkantolo isebenza ngakhona kwenza ke ukuthi umphakathi wonkana uheheke kuleli cala kakhulukazi sibheke ukuthi lo muntu sikhuluma ngaye ke umuntu ke obethanda okanye aziwa ke umphakathi kakhulu bekumuntu odlala ibhola leinyawo manje lokho kwenza ke ukuthi umphakathi wonkana uheheke kuleli cala.
My Lord, there've been this matter has appeared in the press, print media, broadcast media since the event happened, and I think that insofar as the open justice principle I was dealing with is concerned, it's important to bear in mind that certain people wishing to attend court, be it on behalf of the family of the victims or otherwise, are not situated in Gauteng, and insofar as the others are concerned, there may also be limitations of geography and perhaps financial limitations as well.
Manje ke shothi wonke umuntu unokulangazelela ukuthi azi ngaleli cala. Leli cala seliveleke emaphepheni, cala livele kwi-media nje wonkana, kanti ke namalunga ke axhumene nezulu mhlawumbe kuleli cala okanye wonke umuntu okuyingxenye leli cala abekho lana ke eGoli. Manje kuyadingeka ukuthi ulwazi lubafinyelele nabo.
My Lord, the central decision, and I believe this has been referred to on numerous occasions during argument this morning, is the Van Breda judgment, and I believe you have the citation in that regard. So I will address you regarding certain other principles in the heads, but it's important to look at the Van Breda judgment in relation to both access to courts by electronic media, but also in relation to open justice.
Into enyike yavela futhi ilena ke iyecala lika Van Breda isinqumo esathathwa khona lapho ke lelo likhulumisana nale nqubo lena esibiza open justice okanye ke ubulungisa obuvulelekile kanti nangendlela ke lixhumene nendlela ke imedia isebenza ngakhona.
Now, a section of Van Breda which may or may have not been quoted to you, I didn't see it in the small part of the proceedings, appears at paragraphs 11 and 12, and I quote, "It is often expressed by the maxim that justice should not only be done, but should manifestly and undoubtedly be seen to be done. The principle is multifaceted. It insists that trial proceedings be conducted publicly in open court, and ordinarily that is how trials in our justice system are held. The principle of open justice is one which strikes at the very heart of what South Africa has been and is still trying to achieve in the post-apartheid era. The arguments in favor of open justice are perhaps best summarized as follows. First, it assists in the search for truth and plays an important role in informing and educating the public. Second, it enhances accountability and deters misconduct. Third, it has a therapeutic function, offering an assurance that justice has been done as a sense of communal catharsis." End of quotes.
Manje ke kulelo ecala ke elika Breda paragraph 11 and 12 kukhona ke lento esibiza i-maxim okanye ke indlela okanye indlela ethize yokucabanga le egcizela ke ukuthi inkantolo kwamele ukuthi lokho ikhumbule ukuthi umphakathi nawo ke mawuthole indawo yawo emacaleni, kanti ke le nqubo yona lena ke ye open justice yona ke efanele ukuthi nayo ke isetshenziswe kakhulukazi ke kulesi sikhathi ke sesendlule khona lapha kwe apartheid okanye isikhathi se apartheid. Lokho kuyosiza ke ukuthi inkantolo ikwazi ukuthungatha nokuthola iqiniso, kanti ke lokho kuyophakamisa ke amasokiso enkantolo mayelana ke nokuthi ikwazi ukuyiphendulela kanjani emacaleni athize, futhi ke kulaba ke mhlambe abahlukumezekile bangakwazi ke ukuthi bathi ukululama mayelana ke nendlela ke icala lihanjiswa ngakhona.
In conclusion, in regard to open justice, the default position, the rule, is maximum openness, and any limitations on such openness are the exception, which the person seeking such limitations bears the onus to justify with evidence, not mere conjecture. And recall, my Lord, at the beginning, I said that the premise of my argument is that cognizance needs to be given to the fact that in this case, there has been no evidence from the witness, there has been no justification for the conclusions drawn, and accordingly, it is mere conjecture, which it ought not to be.
Gantige okuyiyona ke into emqoka kakhulu ukuthi kufanele ke umuntu ofuna ke ukunciphisa indlela inkantolo isebenza ngakhona alethe ke ubufakazi obuzwakalayo, ubufakazi obuphathekayo, obuzokwazi ke ukuthi uphoqa inkantolo ekutheni inkantolo ingakwazi ke ukuqhubeka ngendlela ejwayelekile ngoba sengishilo ke phambilini lobo bufakazi obunjalo azange bulethwe lana enkantolo obungaphoqa ke inkantolo ukuthi inkantolo isebenze ngendlela engajwayelekile lana enkantolo.
My Lord, the effect of excluding the electronic media means that they, as opposed to the remaining media, cannot use the tools of their trade. The tools of their trade are cameras and audio equipment. They are therefore limited in their ability to exercise their rights in terms of Section 16 of the Constitution, and bear in mind the corollary, that the rights of the public to receive information.
Kanti-ke umthelela wokuthi-ke imedia ingalethwa la enkantolo kanye imedia kungabi ingxenye yenqubo yaleli cala lokho kusho khona ukuthi imedia ingakwazi ukusebenzisa izisetshenziswa zayo kanti-ke isetshenziswa-ke zomsebenzi abawenzayo kanye babizwele wona ukuthi bazokuwenza kanti lokho-ke kuyobe kuqondene nokuthi inkantolo ibhekene ne-section 16 emayelana nalawo malungelo-ke kanti kuyilungelo le-media ukuthi media kube yingxenye yenqubo ekhona lana enkantolo.
In that regard, the majority of South Africans receive news and information principally by means of radio and television. There are limitations on printed media. There are limitations on accessing news via the internet, and substantially the majority of people receive it through television and radio.
Bantu abaningi la enkantolo banitheni batholeke indaba kwi-media ngoba mhlambe ke indaba ebhalwe phansi okanye elothwe phansi okanye ke indaba ke ezilethwa ke ngomfanekiso okamabonakude malunga omphakathi wase South Africa alungeleke ukuthi athole ulwazi ngaleyo ndlela.
Whilst you are at that point, I want to take it. You know that there has been limitations in place where that is concerned, namely where we required that the faces of some of the witnesses be not beamed.
I will certainly get to that, my Lord.
All right.
Because the premise there is, as has been the case to date in this matter, the premise is to have the least restrictive method of permitting the electronic media to broadcast proceedings. And in this instance, certainly an audio broadcast would achieve that purpose.
Manje kahle kahle inhloso ngaba yilena ke ukuthi imedia ikwazi ukusebenza ngendlela ekhululeke kakhulu okanye ngendlela ke engavalelekile okanye kungabi ke nezihibe eziningi ekutheni ke imedia ikwazi ukusebenza. Mhlawumbe ke singaze sisho ke ukuthi uma ke imedia ikwazi ukuthi iqoshe ke imisindo ezwakalayo udlula ke ukuthi kube nalento ukuthi bese kuvela nesithombe somuntu othula ubufakazi okungenani makumane kusetshenziswe ke leyo ndlela yokuqosha ilokhunjani ke imisindo ezwakala ngendlela.
My Lord, I will refer to quote various other cases, but once again I go back to the Van Breda decision at paragraphs 44 and 46, where in part the following was said.
Awuthi ke ngiphindele futhi ke kuleso sinqumo sika Van Breda ngibheke kwi paragraph 44 ne paragraph 46 ingxenye yalokho ke ilotshwe ngalendlela ke.
And I quote, "There simply can be no logic in a court permitting journalists to utilize the reporting techniques of the print media, but not permitting a television journalist to utilize his or her technology and method of communication, being the broadcasting and recording of proceedings, despite the fact that these will be more accurate than a reporter's after-the-fact summary." And further down, "It means that court proceedings must, where possible, be meaningfully accessible to any member of the public who wishes to be timelessly and accurately apprised of such proceedings. Broadcasting of court proceedings enables this to occur. Television presents the complete picture instantaneously. Television cameras do so by creating a comprehensive and instantaneous feedback loop between the trial participants and the television audiences."
Ngafuphe-ke akwenza umqondo ukuthi inkantolo izovumela ukuthi ke kusakazwe nje lokho kungaxoshwa nje ukuthi kuzwe ngamadlebe abantu kuphela sithi ukuthi i-radio kube ukuthi mhlambe i-television yanqatshelwa. Wonke umuntu ufanele ukuthi akwazi ukubona nokuzwa okwenzakalayo mayelana nenhlalo ethize.
Are you saying that where we have been requiring that visual beaming should not include the faces of the witnesses? Are you saying that we should now allow a beaming including the faces of witnesses who have an objection to their faces being beamed?
Well, my lord, I understand that to date, witnesses' faces haven't been broadcast.
Yeah.
Insofar as
and the same media that was here,
yeah,
had no problems with it.
Yeah, then I can't interfere with that, even though it is the first principle of Van Breda is to allow that, but only where a witness shows good reason for it. So I make nothing of that.
Okay.
This is merely an application to continue the proceedings from an electronic media point of view as they have been to date.
Shuthi-ke nalo mbuzo-ke ukuthi ngamanye amazwi-ke uqonda ukuthi siveze-ke ubuso bofakazi la enkantolo. Uthi-ke kahle-ke ngizwisisa-ke ngoba phela-ke inqubo bekuyileyo ukuthi-ke ubuso bungavezwa ukufika namhlanje-ke ubuso bofakazi. Uthi cha uma-ke bekunjalo okanye inqubo ileyo ukuthi-ke ubuso-ke abuvezwa la enkantolo bofakazi, angeke ngikwazi-ke ukugcumkela okanye ukumosha indlela amahlelo abehanjiswa ngakhona-ke. Angeke ngize ngithi-ke asiphoqeni ngamanye amazwi ukuthi ubuso makuvezwe.
And if you could unpack that for me a little, what you are talking about will mean that as a witness testifies, interested members of the public, interested parties in the matter who are not necessarily in the courtroom will be able to hear what the witness is saying from time to time.
That's absolutely correct, my lord.
And what is the status of the accompanying visuals as all that happens? Are the visuals available for viewing at a later stage, or even for preservation for future purposes?
My lord, will you give me a minute to take an instruction in that regard?
Yeah.
Manje-ke umbuzo ilona-ke wokuthi uma ngabe-ke umsindo uyaxoshwa la nenkantolo okanye uyaxoshwa umsindo, ngamanye amazwi-ke inqubo imayelana-ke nokuthi sizwe ukuthi icala loku lihanjiswa kanjani. kunokuthi sibone ukuthi cala lihanjiswa kanjani ke sithini ke ngokubona ukuthi ke awuthi ngeke ngizwe ke ukuthi abazokhuluma nami bathini ngithole ama instructions ukuthi ke manje sizosebenza kanjani ke lapho.
My Lord, to answer your question, as has been the case, and as is always the case when proceedings continue and there's an audio feed, cameras continue to photograph and film in court, but they don't show the face of the witness. However, for the reasons elucidated by my learned friend, once the testimony is over, those fears disappear. And I will make short shrift of the fear of safety. There's no evidence to that, and there cannot be. So ideally, for preservation and archival purposes, and the importance of archival documentation in South Africa is crucially important, the media would like to film but not show live or delayed until a later stage, until perhaps after the trial, the evidence of this witness.
So in this case, it would be for preservation up until the conclusion of the trial.
Yes, correct. So
In
if
other words-
one needs to do
in
a
other
current
words-
affairs program thereafter, one could perhaps use it.
In
Wouldn't
other
go
words,
out live.
in other words, we'll be able to say to the witness, nobody will have the luxury of viewing visuals covering your testimony until after the trial has been concluded.
Sorry, my lord.
Uyazama ke ukuqinisekisa ke ngoba ekhulumisana nenkantolo nje ummeli uthi ke mayelana ke nokuvikeleka akusi yona into kangako efanele ukuthi umuntu ayikhathaze ngayo ngoba ofakazi bavikelekile lokho kusaba kuyophela uma ke sekeqalile phana ngobufakazi bakhe la nenkantolo kanti ke ngoba sikhuluma njena ke sonke lesikhathi ilokhu njani ke imisindo yaxoshwa nanoma ke isithombe singezoba khona kodwa imisindo iyaxoshwa kanti isizathu esenza ukuthi ke simelane kanye nalesi sicelo ukuthi kuyafuneka ke ukuthi shuthi i-television ikwazi ukusebenza lana ukuze abantu bakwazi ukubeka ama-film lawo mhlambe asetshenziselweke amanye amahlelo we-media.
That is the correct position, my lord. Her visuals of her will not be shown till after the end of the proceedings, and it will be shown obviously
The end of the?
End of the trial.
Okay.
And then it would be shown in, for example, a current affairs program, which talks about the trial and what happens. That's where it would be used. And we suggest there can be no objection to that, because she's a well-known public figure. The trial will have been over. Insofar as safety is concerned, well, people know who she is. People know that she's testifying. This is not going to be held in camera. Her evidence is going to be written in the media. She's currently partaking in tweets about this very application. There's nothing secretive, there's nothing scared about this witness. So that is what we ask for.
Yeah, you know, when you speak about tweaks, I am apprehensive of a situation where even this court may come across as pinning her to what she has done. My open view is that we should look at what is happening now and what she is requesting.
Yes.
Because I said the fact that there was mention of even Netflix. And I said, the fact that there has been Netflix, because I'm told that she featured in Netflix, I'm told that she has been active in the social media about this very case. I say that cannot mean only one, or that can not lead to only one supposition. It can number one say you do not mind, you have been doing it, but it can still say you did it and you learned whatever lessons you learned out of it, you no longer want it to happen that way. So I don't want to overly use the past in order to determine inclination for purposes of the request at hand. It wouldn't even be fair. We have all done things from which we have turned at a later stage.
Yes, my lord, I agree with you. We certainly have done things which we all wanted to turn away from later on. But insofar as your last point is concerned, I shall not dwell on Netflix or the interview on eNCA, because the one thing it certainly shows is that she's not camera shy. That's the one thing it certainly does show, that the cameras don't bother her in any way. The reference was to social media was in a sense, in part, to do with that point, because what I'm saying is not what's going on from members of the media in court, but this particular witness, as scared as she might be, is actively tweeting now about these proceedings. So that was really the point I was making insofar as social media is concerned.
Okay.
My lord, I'm not going to burden you with something which I intend dealing with in my heads, and that is as to what we can do to ensure that this type of situation doesn't happen again, where proceedings have to be stood down, so representatives of the media can come to court. There are delays in heads of argument. So that will be something I will make in a suggestion down the line. So my lord, now turning to some of the arguments, as well as the quotes referred to by the state, the important thing is that, and it goes back to the open justice principle, members of the media can still report. The witness has been, will be identified. No objection to her being named. No objection to pictures of her even in the corridor, I understand.
Come again?
I understand that there's no objection to pictures of her even leaving court, insofar as I understand.
Yeah, somebody did say that. Yeah.
Correct. So there's nothing hidden about her being in court. Can't be any issues of safety. You know, she's saying, "Hi, here I am. You can photograph me leaving court. I've just given evidence. And if you want to read about my evidence, well, read about it in the newspapers." Also, as I said, the court is open to several hundred people, and I see there are quite a few people there, and they will have direct access to the evidence.
And taking a leaf from the past experience in this very case, to which both you and I and everybody else who was here is remain privy, that whatever happens in the passages should stop short of the incident we had with Tumelo Madlala, who literally had to run as if for dear life through the passages with the media in hot pursuit.
My lord, that incident made you as unhappy as it made me, having been in the media space for many, many years. And rest assured, I had my own words to say about that, and I think members of the media now understand the do's and don'ts and what they shouldn't do. So,
okay.
mayelana ke neyithombe ukuthi zivezwe akusona inkinga kangako kodwa ke kusobala ke ukuthi ube lokho yenza ama tweets lana ke lo fakazi lona ke ubenza ama tweets kanti lokho ke kuyabonisa ukuthi kangaka kusiyena umuntu osaba ukuthi kuvezwe izithombe zakhe okunye ke akucacisayo lana ukuthi inkosi enkantolo ethi yabona ke iyo lento enza ukuthi ke ngibe nenkinga ngoba phela ke angifuni ukuyithola sengithena ngoba esikhathini esendlule ukwazile ukwenza lokhu nalokhuya ngaleyo ndlela ke uyohlulwa yini ke ukuthi akwenze lokhu lana enkantolo ngoba kunokwenzeka ukuthi emva kokuthi akwenze lokho akwenzile egcizelela kakhulu kule film le ye-Netflix kungenzeka ke emva kokuthi ke kuthethule leyo film ye-Netflix ukuthi kuye kwaba nezinguquko ezithize inkantolo ke ayifuni ke ukuthi ithathele umuntu isinqumo esithize ukuthi ke ngoba uke wakwenza lokho phambilini namanje angakwazi ke ukuthi azothula ubufakazi bakhe lana enkantolo ummeli ke naye uyagcizelela ke kuma social media la uyaziwa kanti akusena umuntu osaba ikamera ke kanjalo futhi uyayisebenzisa i-Twitter mhlawumbe okanye uyatweeta nakuyimanje nje ngoba sikhuluma mhlawumbe into nje esingayikhuluma ke futhi ukukhuluma ummeli lapha engayisho nje ukuthi lesi sigameko esenzeke la enkantolo ngalesi hlakalo esenzeke la enkantolo ukuthi ufakazi anqabe ukuthi kusetshenziswe ke amakhamera la enkantolo yinto ekumele sizame ukuthi esikhathini esizayo ayenzeki la enkantolo mangichubeka ke ngizogcizelela khona lapha kule nkambo ye open justice kanti ke laba ke abazosebenza la futhi ke amalunga wemedia okanye ithimba lemedia ngiletha okanye ngithula lokho ukuthi mabachubeke basebenze kanti ke ngizwile ukuthi ukukhulumile ke lokho ukuthi uma ngabe kuthathwa izithombe nje khona la emapassage akanankinga nalokho lokho ke kuqinisa ke ukuthi akekho umuntu ozolahlekelwa ke lana kakhulukazi sibheke yena lo fakazi abantu banelungelo lokuthi bangakwazi ukuthi bathole ulwazi ngobushilo ke ukuthi uma kukwaziwa ukuthi ku-report ngaleli cala emva ukuthi icala lenzeke okanye kungasetshenziswa amakhamera abantu bazokwazi ukuthi bathole ulwazi mayelana naleli cala kusetshenziswe ke nalesi sigameko sikaTumelo Madlala ebaleka ke lana emapassage othi ke yinto ke esingayifisi ukuthi yenzeke ngeshwa ke iyenzeka kodwa ke yinto esingathanda ukuthi ingenzeka leyo nto leyo. Thank you, my lord.
So then turning to the grounds raised by my learned friend, the first is safety. I think we've dealt with it. Just to repeat, there's no evidence as to why this witness fears for her safety if her voice, the evidence of her voice in audio recording is broadcast live. There needs to be such evidence in accordance with the principles of Prandbredar. Principles of Prandbredar say it cannot merely be conjecture. And my learned friend merely saying that she fears for her life based on absolutely not a tittle of evidence is and can only be defined as mere conjecture.
Yabona lo mbuzo ukuthi impilo yakhe izobe ivikelekile noma cha akusona umbuzo kangako ekumele siwubuze ke wona lo uma ngabe ke kuyoxoxwa nje iphimbo okanye ivoice yakhe uma sokusichubeka ngaleli cala akekho umuntu ke ozolahlekelwa khona lapho.
Secondly, the point that this puts pressure on her and makes her uncomfortable. Again, mere conjecture. She hasn't said that she's going to be uncomfortable, and quite frankly, I think any evidence in that regard should be dismissed with the contempt it deserves. This is a woman who has gone out, made media statements, publicly spoken about the matter, whether on television or otherwise. She has done so without any form of discomfort.
Naleli phuzo ke aliphakamisile ke mayelana ukuthi ke uma kuzosetshenziswa ngendlela enjalo ukuthi kube namakhamera kanjalo kuyomfakela incindezi lobo bufakazi sithi ke futhi ke lawo mahemhem sithi ke thina ke mawaqithwe ngoba abukho ubufakazi obulethiwe lana enkantolo kanti inkantolo mayicekele phansi okanye mayicekele phansi leyo nkulumo yakhe yokuthi uzobe engaphansi kwencindezi kanjalo.
The statement that from the bar that she won't give evidence if proceedings are live, that can also be dismissed rather quickly. Nothing like a subpoena to get a witness to give evidence.
Manje nalokho ke ukuthi yena angeke akwazi ukuthi abuthule ubufakazi bakhe uma ngabe ke enkantolo ayikwazi ukuhlonipha isicelo sakhe. Ayikho into enjalo. Make umuntu esenikezwe ke isubpoena ukuthi makalethe ubufakazi la enkantolo kwamele ukuthi akuhloniphe lokho.
My Lord, if this witness were to give evidence, why live broadcasting would hinder her testimony? Not only would she have to explain it, but she'd have to explain it in the context of the other witnesses and the manner in which they have given evidence. Mere suggestion of public scrutiny goes nowhere. By being in open court, with the court being full, she is subject to the same public scrutiny. By having her evidence reported on, what she says, she's open to the same public scrutiny. So the fact that she says that this may, there was a word which was used, this may make her uncomfortable, I think that carries no probative value at all. It'll unsettle her. So my Lord,
ubufakazi ngoba ezobuletha njena ke mhlambe kumlethela incindezi kanjalo nokuthi angeke akwazi ukuthi yena aqhubeke enkantolo ngaphandle ukuthi ke inkantolo ihloniphe leso sinqumo okanye leso sicelo. Inkantolo iyofanele ukuthi ibheke ukuthi nalabo abanye phela abake bathula ubufakazi la enkantolo nabo baye babhekana nayo inselelo ukuthi amalunga omphakathi aloko ebhekisisa ke ubufakazi babo ukuthi mhlambe ke abavumelana nalokhiyana okanye bavumelana nalokhiyana wonke umuntu obekhona la enkantolo ukwazile ukuthi ayithola bengaphansi kaleyo ncindezi ukuthi amalunga omphakathi akwazi ukuphakamise uvo lwawo mayelana ke nomuntu othize othula ubufakazi la enkantolo. Kunalento ayikhulumile ke emayelana ukuthi ke akaneme ekutheni ke athula ubufakazi ngaleyo ndlela. Inkantolo mayibheke nalabo abanye abebekhona phambilini ukuthi ngabe bekhululekile yini bona ngaleso sikhathi ke okanye babevikelekile ekutheni umphakathi ungakhiphi uvo lwawo mayelana nabo.
Now my Lord, I suppose turning to the crux of the argument, and I think it's the crux of the argument for everyone, and that is the legal position set out in Van Breda. And my learned friend referred to certain paragraphs. I would suggest the whole case is relevant, but in any event, I intend to refer to various other paragraphs.
Abasebenzi kanye nami ke basebenziseke okanye babaleke imi-committees okanye inqubo ethize eqhamuka khona laphayana ke kulama paragraph waleso sinqumo senkantolo sika-Van Breda. Kanti-ke mina ngasho ukuthi lonke lelo cala-ke libalulekile kakhulu kuleli cala esibhekene nalo manje.
And the reason I do so is that my learned friend left out certain crucial parts of the Van Breda decision. So I will turn to paragraph 61 of the Van Breda decision.
Khona-ke izinto ezimqoka ey'qukethwe yileso sinqumo saka Van Breda, paragraph 61. Ziye zashiyeka-ke lezo zinto engizokwazi ukuthi-ke ngiyiphakamisela enkantolo namhlanje ngoba-ke ngiveza le paragraph 61.
The nub of that paragraph is that one cannot have a rigid one-size-fits-all approach. And
Manje-ke ngeke sikwazi ukusho-ke ukuthi sithi okwenzeka kuloyana nakuloyana-ke kumele kwenzeke ngokufana. Futhi-ke ilokho okuvezwe lapho.
I think I should quote this from paragraph 61. Moreover, the fact that witness X might be severely intimidated by having to testify on camera does not justify prohibiting broadcast of Y's testimony, who has not raised the same concern. And this is the important part. Nor would it, without more, justify prohibiting the audio broadcasts of witness X testimony. Such an approach does afford appropriate appreciation for the different types of witnesses who are testifying in the course of criminal proceedings, and they do mention lay witnesses.
Futhi-ke leso sinqumo-ke kuthiwa wonke umuntu kumele abhekwe ngelihlo okuyilona iso elifanelekile ukuya ngendlela ayiphatha ngakhona lana enkantolo, ukuthi mhlawumbe-ke kuye kwathethula nje mhlawumbe umsindo ngaphandle ukuthi kube namakamera ukuthatha isithombe. Angeke sikwazi-ke ukuthi ngenxa-ke yokusaba kufakazi othize bese siyasho ukuthi naloyana-ke kwamele ukuthi abe ngaphansi kwaleso simo esiye saba khona kulo omunye.
In the same paragraph, the learned judge says, and again I emphasize this, I venture that it may be fanciful to suggest that an audio broadcast can have the same distressing or embarrassing effects as an audio-visual broadcast. And again, I refer back to the evidence given from the bar. There is nothing to deal with that.
Manje-ke lo judge-ke uyasho ukuthi ubufakazi omayelana nokuthi-ke umuntu uma kuthethula nje mhlawumbe okanye uxosha umsindo kuphela kungasetshenziswa amakhamera-ke wesithombe, akusho-ke ukuthi mhlawumbe incindezi izobe iphelile uma kwenziwa ngaleyo ndlela.
Then, my Lord, if we could also turn, I turn to paragraph 73 of the same decision. And again, it's important to quote this paragraph in full. The judge held as follows. If the judge determines that the witness has a valid objection to cameras, alternatives to regular photographic or television coverage could be explored that might assuage the witness's fears. For example, television journalists are often able to disguise the identity of a person being interviewed by means of special lighting techniques and electronic voice alteration, or merely by shielding the witness from the camera, as we suggest should be done here. In other instances, broadcast of testimony of an objecting witness could be delayed or until after the trial is over. If such techniques were used in covering trials, the public would have more complete access to the testimony via television, and yet the witness would maintain some degree of privacy and security.
Paragraph 73 ke kuleyo judgment leyo kanye leso sinqumo uma ngabe ke i-TV okanye ke mhlambe kusetshenziswa ke neyithombe kanjalo ke lokho ke okungiqoka kakhulu ukuthi i-TV yona kuyakwazi ukuthi kube nalengxenye yayo ukuthi kungaveli ubuso bomuntu bayakhona ukuyenza leyo nto leyo ukuvala ke umfanekiso omayelana ke nesithombe salowo muntu lo kanti ke uma kungukuthi inkantolo iyachubeka kube ukuthi ke inkantolo ichubeka njena kungukuthi iqala selipheli sengisho ukuthi inkantolo iyakwazi ukuchubeka ngaphandle ukuthi mhlawumbe kungasetshenziswa ke ama-camera emva kokuthi ke iqala seliphelile bese kusetshenziswa ke lezo ithombe okanye lawo mafilimi lokho kuzokwenza ke ukuthi ufakazi angazizwa ukuthi ke uye wabekwa okanye wabekwa ngaphansi kwencindezi engafanele kanti lokho ke kuyosiza umphakathi ukuthi ukwazi ukuthola ukuthi kwenzakaleni ngalelo cala.
Lord, I think my time is pretty much out. I will refer you to paragraph 75 of the decision in my heads. But in the meantime, in concluding, just to say that in making any decision insofar as any particular objecting witness is concerned, one needs the least restrictive approach. And what has been suggested in this regard is the least restrictive, and the witness has not, as she is required to do, demonstrated any prejudice, and that there's a real risk that such prejudice will occur rather than there's just mere conjecture. And for those reasons, my Lord, I suggest that the applicant has not made out a case as to why members of the electronic media should be excluded for this witness's evidence, as the court pleases.
Manje ke engikushoyo ke ngiyabona ukuthi isikhathi sami sesingiphelele njalo kanti ke bengizokwazi ukuthi ke ngithi ukuqondisa inkantolo kuyilokho njani ke ku paragraph 75 yaso sona lesi sinqumo engacela nje la inkantolo ngafuphe ukuthi makusetshenziswe inqubo engezovimbela ukuthi ithimba le media likwazi ukusebenza ngokukhululekileyo.
Thanks. Advocate Baloyi.
As a court, please, my lord, I'm ready to respond. I just see that we have almost reached the normal court sitting time. I think that there'll be about 10-15 minutes.
We have to hear from those who transport some of the people. As a court order, can we find out from the people how safe it is to go beyond now? So Baloyi, who is answerable about the travel?
We can then adjourn to tomorrow. We will submit written heads of argument. Leonard Friend is suggesting that maybe the proceedings themselves be adjourned to Wednesday, but I suppose the matter will still be argued tomorrow, and the accused have got to be here. So.
No, my lord. My lord, the arrangement prior was that the state will submit their heads today, my lord, by 4, and then tomorrow by 4 o'clock we will also submit our heads. Then we can argue the matter on Wednesday morning or have a ruling if there is no need for argument. So
but tomorrow will Advocate Baloyi not argue?
Argue on what, my lord?
Responding to all that you were saying.
We haven't finished our cases, my lord, because we are still going to file the heads. My lord, the state has brought its application. The defense has responded.
Yeah.
Now the directive from the Honorable Court is that we all file our heads.
Yeah.
Then after that, then the state can respond.
If he chooses to wait for that, if he chooses to respond even by tomorrow before the heads are in, can he not do that?
That will be on procedural, my lord.
There you are.
Even responding now, because I sat down before I could finish my application, bringing my application, if I can remind his lordship. But I sat down because the advice from his lordship was that we prepare our heads. And then I had to stop my address, my lord. So that will be concluded in my heads of arguments, my lord. Then after all the heads have been filed before this court, then the court can invite then the oral arguments from the party.
My lord, we are in the hands of the court. We will file our heads of argument as requested, and perhaps if the court would like to give directives as to the timelines, we will abide by that, my lord.
I think the timelines have been agreed upon. We don't need to revisit that. The only issue here which is arising is that, or let me tell you how I see this. You have made the application. They have responded,
Yes.
and some of them were saying part of their response is not coming out as they address, but will be included in their heads.
Yes.
And from where I'm sitting, it was your chance to respond to what they have said.
Yes.
Around it. That's all that I think should happen. And because of time, which you would have been doing now as we speak,
Yes.
but because of time, we are rolling the matter over until tomorrow. Whatever anybody did not have a chance to say, just as Mr. Rosengarten told us that there's part of what he should have been saying now, which is not, but which will nonetheless be included in his head. So what remains to happen now is for you to address court in the light of what they have stated in addressing court.
As the court, please, my lord.
And as for the timelines, the same. You said by today. I can't remember whether you said by today or whatever it is. It will be such that they will have time to look at what we have said, stated in your heads, and they will. I think Advocate Mnisi even spoke about research with a view to submitting their heads by 4 o'clock tomorrow.
As a court, please, my lord.
May the accused rise. This case is postponed overnight for further hearing. It's postponed with the accused in custody, postponed to the 16th of May 2023.
Icala liyahlehliswa ukufika-ke day 16 namazuka 16.
My Lord, if I may, on this side of the table, there's certainly some confusion because heads of argument from the attorneys and legal representative of the accused and our heads of argument will only be due at 1600 hours on the 16th, which is tomorrow. So we thought that the matter would be postponed until after the heads of argument are filed and argument would be concluded on Wednesday the 17th. Yeah, Wednesday the 17th.
Advocate Aloy?
We are amenable to that, my lord. It's no problem.
So we postpone until Wednesday, the 17th.
Futhi-ke manje icala thathelwe emuva ukufika i-17 kulesithathu. Sophinde sibuye-ke futhi ngoba kwangathi kukhona ama-head of arguments okanye amaphuzu okuphikisana akumele ukuthi mhlawumbe afakwe kusasa ngabo okungenani ngo-4 o'clock yantambama. Ngaleyo ndlela-ke futhi-ke icala kuyomele ukuthi livele futhi lana enkantolo ngeyi-17 zikaMeyi 2023. Thank you, my lord.
Nice.